Hello friends, welcome to Legal Perspectives, the third sub-module under Safety in the course Health, Safety, Environment Protection or HSE. HSE consists of 4 main modules that will cover the above-mentioned aspects in detail. Click here to view the learning outcomes for Legal Perspectives.
Learning outcomes. After going through this module, you will be able to
understand how the ILO or International Labour Organization works and how it contributes to the health, safety and welfare of the workers worldwide. Understand the legal framework in India. Understand the difference between the central acts and the state rules. Demonstrate an understanding of the powers of statutory inspectors and the employer's rights and obligation with reference to HSSE during the inspection visit of the inspectors. Explain various provisions of Factories Act 1948 and the model rules developed thereunder and the Building and Other Construction Workers Act 1995. You've familiarized yourself with the objectives of this module. Now, here's an overview of the International Labour Organization. ILO is a specialized agency of the United Nations dedicated to the improvement of labor conditions and their living conditions throughout the world. It was established in 1919 as an agency of the League of Nations. It became the first specialized agency affiliated to the UN in 1946. The ILO's activities include compiling labor statistics, protecting international migrants, and safeguarding trade union rights. About 185 countries are represented in the ILO. It received the Nobel Prize for Peace in 1969 for its work towards the betterment of labor force worldwide. The primary goal of the ILO, as stated by its Director General, is to promote opportunities for women and men to obtain decent and productive work in conditions of freedom, equity, security, and human dignity. While working towards this goal, the ILO seeks to promote employment creation, strengthen fundamental principles and rights at work, workers' rights, improve social protection, and promote social dialogue, as well as provide relevant information, training, and technical assistance. Let's continue with the discussion on the International Labour Organization. The ILO's work is categorized into the following 4 groups. Promote and realize standards and fundamental principles and rights at work. Create greater opportunities for women and men to decent employment and income. Enhance the coverage and effectiveness of social protection for all. Strengthen tripartism and social dialogue. The ILO hosts the International Labour Conference in Geneva during the month of June every year. At the conference, conventions and recommendations are crafted and adopted by a majority decision of the attending members. The conference also makes decisions on the ILO's general policy, work program, and budget. You have been introduced to the International Labour Organization. Now, let's look at the International Labour Conference. Each member state is represented at the International Labour Conference by 4 delegates. 2 government delegates, an employer delegate, a worker delegate. All delegates have individual voting rights and all votes are equal regardless of the population of the delegate's member state. The employer and worker delegates are normally chosen in agreement with the most representative, national organizations of employers and workers. Usually, the workers' delegates coordinate their voting, as do the employers' delegates. You have explored the International Labour Conference. Now, let's look at the adoption of conventions. One of the principal functions of the ILO involves setting international labour standards through the adoption of conventions and recommendations, and which, together, are sometimes referred to as the International Labour Code. Adoption of a convention by the International Labour Conference allows member governments to ratify it, and the convention then becomes a treaty in international law when a specified number of governments have ratified it. You have been introduced to the adoption of conventions. Now, let's look at the ratification of conventions. It is a legal obligation to apply the provisions of a convention by the nations that have ratified it. Ratification of a convention is voluntary. Conventions that have not been ratified by member states have the same legal force as recommendations. Governments are required to submit reports detailing their compliance with the obligations of the ratified conventions. Every year, the International Labour Conference's Committee on the Application of Standards examines a number of alleged breaches of international labour standards. In recent years, one of the member states that have received the most attention is Myanmar, erstwhile Burma, as the country has repeatedly been criticized for its failure to protect its citizens against forced labor. You have explored ratification of conventions. Now, let's look at the subjects of conventions. All adopted ILO conventions are considered as international labor standards regardless of how many national governments, that is, member countries, have ratified them. The topics covered by them cover a wide range of issues, from freedom of association to health and safety at work, working conditions in the maritime sector, night work, discrimination, child labor, and forced labor. You've been introduced to subjects of conventions. Now, let's examine Declaration of Fundamental Principles and Rights at Work. In 1998, the International Labour Conference adopted the Declaration on Fundamental Principles and Rights at Work. This declaration identified 4 areas as core or fundamental international labour standards, meaning that any ILO member state should have ratified at least 8 key conventions which concern with freedom of association, the right to organize and to collective bargain, discrimination and forced labor, child labor. These core or fundamental standards have all been ratified by the overwhelming majority of ILO member states. You have been introduced to the Declaration of Fundamental Principles and Rights at Work. Next, let's look at some criticisms and recommendations that the ILO has received. Criticisms. Despite the rapid ratification by many countries of the 8 conventions identified as fundamental, many academics and activists have criticized the ILO for creating a false division between different international labor standards, many of which cover specific and concrete human rights topics, but were excluded from the 1998 declaration, such as those on health and safety and working hours. Recommendations. Recommendations do not have the binding force of conventions and are not subject to ratification by member countries. Recommendations may be adopted at the same time as conventions to supplement the latter with additional or more detailed provisions. The intent of these recommendations is often to more precisely detail the principles of related conventions. In some cases, recommendations may be adopted separately and address issues not covered by or unrelated to any particular convention. You have examined the ILO from a global perspective. Now, let's look at the Indian scenario. ILO has 18 conventions that are targeted at addressing the issue of occupational safety and health, or OSH. Though India has ratified 41 ILO conventions and treaties on labor welfare and labor rights to date, it has ratified only 3 conventions on OSH. India is still to ratify important conventions such as Convention 155 on OSH and the working environment, Convention 161 on occupational health services, Convention 167 on safety and health in construction, Convention 176 on safety and health in mines, Convention 184 on safety and health in agriculture, Convention 187, the promotional framework for occupational safety and health. You've been introduced to the International Labour Organization. It's time to take a safe shot. Choose the correct option. Which of the following conventions covers safety and health in agriculture? Not quite. You have explored the International Labour Organization in detail. It's time now to explore the legal framework in India. Legislation on occupational health and safety has existed in India for over 50 years. The principal health and safety laws are based on the British Factories Act. The Factories Act 1948 has been amended from time to time, especially after the Bhopal gas disaster, which could have been prevented. The amendment demanded a shift away from dealing with disaster or disease to prevention of its occurrence. The Factories Amendment Act came into force on December 1, 1987. A special chapter on occupational health and safety to safeguard workers employed in hazardous industries was added. In this chapter, pre-employment and periodic medical examinations and monitoring of the work environment are mandatory for industries defined as hazardous under the Act. A maximum permissible limit has been laid down for a number of chemicals. Let's continue exploring the legal framework in India. The Factories Act is implemented by state factory inspectorates supported by industrial hygiene laboratories. There are similar provisions under the Mines Act. The Factories Act is applicable only to factories that employ 10 or more workers. It covers only a small proportion of workers. Safety and health occupy a significant place in India's constitution, which prohibits employment of children under the age of 14 in factories, mines, and hazardous occupations. This policy aims to protect the health and strength of all workers by discouraging employment in occupations unsuitable to the worker's age and strength. It is the policy of the state to make provisions to secure just and humane conditions at work. The Constitution provides a broad framework under which policies and programs for occupational health and safety can be established. You have been introduced to the legal framework in India. Now, let's look at the status of OSH regulations. India has had legislations on occupational safety and health for 50 years. The number of enforcement officers attached to various regulatory authorities are grossly inadequate even for the inspection of formal units that only employ about 10% of India's total workforce, that is, around 26 million, let alone the millions who work in the informal sector with absolutely no safeguards. It is estimated that unsafe work conditions is one of the leading causes of death and disability among India's working population. These deaths are needless and preventable. Unlike growth rates and GDP figures that are flaunted every quarter, the figures of dying and ailing workers who make this growth possible are never recorded or spoken about seriously in many of the developing countries, including India. Let's learn more about the status of OSH regulations in India. ILO estimates that around 4,03,000 people in India die every year due to work-related problems. In other words, more than 1,000 workers die every day from work-related diseases, which is approximately about 46 persons dying every hour. Though these figures are alarming, they might be a conservative estimate, as the ILO does not receive complete and reliable data from many countries. For example, in the year 2003, India reported 179 fatal accidents, while the ILO put the estimate at 47,000. There are no reliable figures for occupational diseases either. The ILO arrives at these figures by extrapolating them from developed countries such as Denmark, where every accident and disease is reported. You have explored the status of OSH regulations in India. It's time now to examine the key OSH legislations in India. Dangerous Machines Regulations Act 1983. Dock Workers Safety, Health and Welfare Act 1986. Explosives Act 1884. Factories Act 1948, amended in 1954, 1970, 1976, 1987. Indian Atomic Energy Act 1962. Indian Boilers Act 1923. Indian Electricity Act 1910. Insecticide Act 1968. Manufacture, Storage and Import of Hazardous Chemicals Rules 1989. Mines Act 1952. Petroleum Act 1934. Plantation Labour Act 1951. Radiological Protection Rules 1971. Now, let's learn more about the key OSH legislations in India. The Directorate General of Factory Advice Service and Labour Institutes, or DGFASLI, assists the Labour Ministry in formulating national policies on occupational safety and health in factories and docks, and enforcing them through inspectorates of factories and inspectorates of dock safety. Similarly, the Director General of Mines Safety, or DGMS, Ministry of Labour, is responsible for the health and safety of mine workers and implementation of the Mines Act 1952. There are also two key laws covering worker compensation and welfare. They are Workmen's Compensation Law, by which a worker can claim compensation under establishments covered by the Factories Act. Employees State Insurance Act, or ESI Act, which is a contributory social insurance scheme that protects the interests of workers in contingencies such as sickness, maternity, employment injury causing temporary or permanent physical disability or death, loss of wages or loss of earning capacity. As of March 2006, there were 35.4 million beneficiaries under this scheme. You have been introduced to the legal framework in India. Now, let's look at occupational diseases and their diagnosis. Accidents, despite being visible, are still grossly underreported in the Indian context. Reporting of occupational diseases, therefore, stands very little chance. If you analyze the details of workers who die because of their work environment, you find that, surprisingly, most of them succumb to occupational cancers and other work-related illnesses. This is contrary to the common belief that most work-related deaths are caused by accidents. In most places, occupational safety and health invariably means prevention of accidents. Very little attention is paid to occupational diseases. An accident-free workplace by no means implies a safe workplace. Now, let's learn more about occupational diseases. Occupational diseases, including cancers caused by various materials in the workplace, such as asbestos, silica, cotton, dust, and radiation, usually take a long time to develop, from a few months to more than 10 years. Given changing work practices, most industries tend to hire workers on a short-term contract. By the time they develop a disease, therefore, it is almost impossible to link it to their work. Non-communicable diseases result in more deaths than communicable diseases, except in Africa. Overall, people are more likely to die of work-related diseases than childhood or infectious diseases. Not many doctors are able to correctly diagnose an occupational disease. In fact, certain occupational diseases, such as byssinosis, a lung disease caused by cotton dust, and silicosis, a lung disease caused by silica dust, are often wrongly diagnosed as tuberculosis. In a community where having a doctor is a privilege, an OSH specialist is simply out of the question. You have been introduced to occupational diseases and their diagnosis. Now, let's look at the informal sector problems. Most workers in India, that is, 90%, work in the vast informal sector. The variable and insecure nature of the work means that more and more workers are pushed into taking up hazardous and precarious employment, both in the informal economy as well as informal work in the formal sector. For these workers, employment not only fails to bring about a successful escape from poverty, it may contribute to existing vulnerabilities. There are other contributory factors that lead to poor working conditions in the informal sector. There is very little awareness about workplace hazards due to lack of access to information or even any kind of formal education. Then too, OSH is given very low priority among informal workers, as having work is more important than the quality of the job. As many workers say, we might die of work, but if we don't work, our families will die of hunger. Let's continue with the contributory factors that lead to poor working conditions. The other contributory factors that lead to poor working conditions in the informal sector include: no proper work hours. Piece rate work often leads to exploitation and extended exposure to hazardous chemicals and processes. Diagnosis of occupational diseases is difficult even in the formal sector. In the informal sector, it is almost impossible. In the absence of proper diagnosis, treatment of occupational illness is next to impossible for workers in this sector. No clear distinction between living and working area complicates the problem and exposes relatives and others living in the vicinity to work-related risks. You have been introduced to informal sector problems. Now, let's look at the effects of hazards on women and children. If information on OSH hazards among informal workers is poor, their impact on women's health is even less understood. In addition to paid work, women also do other demanding jobs such as cooking, cleaning, and taking care of children. The extended work hours put tremendous pressure on women's bodies and minds. Women also face an increased risk of musculoskeletal disorders because of the repetitive nature of the jobs they perform and having to work in uncomfortable positions for long hours. Sometimes they work with babies in their laps or on their backs. Women who work with chemicals such as solvents in adhesives, in home-based work, or pesticides out in the fields are also in danger of chemical poisoning. Working pregnant women expose their unborn children to great risks. Child labor is a big problem in the informal sector in India. Children in the informal sector sometimes have to help their parents for economic reasons. The growing bodies of children are more susceptible to hazards at the workplace, but since children legally are not supposed to work, very few initiatives are targeted at improving their working conditions. You have explored the legal framework in India. It's time to take a safe shot. Choose the correct option. In Africa, more deaths occur as a result of communicable diseases as compared to non-communicable diseases. Well done. The statement is true. In Africa, more deaths occur as a result of communicable diseases as compared to non-communicable diseases. You have been introduced to the legal framework in India. It's time now to explore powers of enforcement inspectors. Enforcement authorities usually have a variety of powers that enable them to deal with breaches, that is, non-compliance of legislation and other situations that they consider to be unsafe. These powers can result in enforcement action or actions, the extent of which depends on the gravity of the non-compliance. Enforcement action can take several paths. Click here to learn more about enforcement action. You have been introduced to powers of enforcement inspectors. Now, let's explore the improvement notice in more details. An improvement notice may be served where an inspector is of the opinion that a person is contravening one or more statutory provisions or has contravened in the past and is likely to continue or repeat it. An improvement notice will give reasons as to why an inspector has formed this view and will require the person to remedy the alleged contravention within a specified time period, which will be at least 21 days following service of the notice. An appeal can be made on one of the following three grounds: against the service of the notice, the contents of the notice, the time limit given for compliance. An industrial tribunal can then do one of the following three things: cancel the notice, affirm it with modifications. Bringing an appeal suspends an improvement notice until either the appeal is heard or withdrawn. You have been introduced to the improvement notice. Now, let's look at the prohibition notice. A prohibition notice can be served by an inspector if he is of the opinion that work activities being carried out under the control of a person will involve a risk of serious personal injury. There is no need to any specific statutory provisions to have been breached, although, in practice, this will almost invariably be the case. The existence of the risk of serious personal injury is in itself sufficient to justify service of a prohibition notice. The effect of the notice is to prevent the activity, which is specified in it, from being carried on until matters are remedied to the inspector's satisfaction. A prohibition notice should specify what matters the inspector considers give rise to a risk of serious personal injury. If the activities do involve a breach of legislation, the inspector should specify what that is and why he is of the opinion that the legislation has been breached. Let's continue with the discussion on the prohibition notice. The activities specified in the notice cannot be resumed until the inspector is satisfied that the risk of personal injury has been removed. A prohibition notice will usually take immediate effect, but can be deferred to take effect at the end of a period specified within the notice, that is, in circumstances of certain chemical processes where an immediate stop would not be safe. An appeal can be made against one of the following three things: the service of a prohibition notice, the contents, the time limit given for compliance. An industrial tribunal can do one of the following three things: cancel the notice, affirm it with modifications. Bringing an appeal does not suspend the prohibition notice. If the person served with the notice wishes to have it suspended, an application must be made to the industrial tribunal in advance of the appeal being heard. It is an offense to contravene any requirement or prohibition imposed by an improvement or prohibition notice, including where the notice has been modified on appeal. You have explored powers of enforcement inspectors. It's time to take a safe shot. Choose the correct option. A prohibition notice can be served by an inspector if he is of the opinion that work activities being carried out under the control of a person will involve a risk of serious personal injury. Well done. You have been introduced to the powers of enforcement inspectors. Now, let's look at the Building and Other Construction Workers Act, 1996. Click here to learn more about the Act. You have been introduced to the Building and Other Construction Workers Act, 1996. Now, let's discuss a few chapters in more detail. Let's look at Chapter 6 first. Click here to learn about some sections of Chapter 6 of the Workers Act, 1996. Here, let's continue with the sections of Chapter 6. Click here to learn about some more sections of Chapter 6 of Workers' Act 1996. You have explored the sections of Chapter 6 of the BOCW Act 1996. Now, let's look at Chapter 7. Click here to learn about sections of Chapter 7 of BOCW Act 1996. You have been introduced to the sections of Chapter 7 of the BOCW Act 1996. Now, let's explore Chapter 8 in detail. Click here to learn about sections of Chapter 8 of BOCW Act 1996. You have been introduced to the sections of Chapter 8 of the Building and Other Construction Workers Act 1996. Now, let's explore Chapter 10 in detail. Click here to learn about some sections of Chapter 10 of the BOCW Act 1996. Here, let's continue with Chapter 10. Click here to learn about some more sections of Chapter 10 of BOCW Act 1996. You've been introduced to the Building and Other Construction Workers Act 1996. It's time to take a safe shot. Drag the appropriate option and drop it in the blank. Introduced to the Building and Other Construction Workers Act 1996. It's time to take a safe shot. Drag the appropriate option and drop it in the blank. Well done. The Director General, the Chief Inspector, and every inspector shall be deemed to be public servants within the meaning of Section 21 of the Indian Penal Code. Here are the key concepts that have been covered. The International Labour Organization, or ILO. It was established in 1919 as an agency of the League of Nations. About 183 countries are represented in the ILO. It received the Nobel Prize for Peace in 1969 for its work towards the betterment of labor force worldwide. ILO's work is categorized into the following 4 groups: standards and fundamental principles and rights at work, employment, social protection, social dialogue. Legal framework in India. The Factories Act 1948 has been amended from time to time, especially after the Bhopal gas disaster, which could have been prevented. The amendment demanded a shift away from dealing with disaster or disease to prevention of its occurrence. Director General of Mines Safety, or DGMS, Ministry of Labour, is responsible for the health and safety of mine workers and implementation of the Mines Act 1952. 2 key laws covering worker compensation and welfare. They are Workmen's Compensation Law, Employees State Insurance Act, or ESI Act. Here are the key concepts that have been covered. Powers of enforcement inspectors. Enforcement authorities usually have a variety of powers that enable them to deal with breaches, that is, non-compliance of legislation and other situations that they consider to be unsafe. Enforcement action can take several parts, that is, informal and formal. An improvement notice and prohibition notice served by inspector. The Building and Other Construction Workers Act 1996. This act covers 11 chapters, which includes dealing with preliminary, advisory or expert committees, registration of establishments, registration of workers as beneficiaries, welfare boards, welfare facilities to be provided, health and safety at workplace, inspectors and penalty procedures.